Good evening to everybody. And today topic is strict construction of the taxing statutes, which is a part of the interpretation statute. That is a second year, second semester course. Our scheme or flow of online lecture, that is a class is given below, which is said to be the bird's eye view. And there I have mentioned introduction, tax systems in India, taxation, the tax laws, principle of strict construction, and the charging section, how it plays a role in the statutes, and what would be the clear intention to impose the or increase the tax, and what is the intention of the parliamentarian for making the such statutes, and what would be the prospective operation of the statutes, meaning in common parlance and machinery provisions, and no presumption as to tax, fiscal statute to be read as a whole, and no spirit of law and substance of the matter. And we see that how the exemption clause, even exemption clause also be construed strictly. Later part we will see the conclusion. That is the part of our today's online lecture. Let us see the introduction. In introduction, in regard to tax legislations, that is income tax acts and fiscal acts, that is the statutes, that are financial acts, in particular, the language imposing the tax must receive a strict construction. In a taxing act, one has to look at what is clearly said. There is no room for any entailment. There is no equity about a tax. There is no presumption as to a tax. And nothing is to be read in, and nothing is to be implied. One can only look fairly at the language used in the statute. Statutes imposing taxes or monetary burdens are to be strictly construed. The logic behind this principle is that imposition of taxes is also a kind of imposition of a penalty, which can only be imposed if the language of the statute unequivocally says so. Any kind of indictment, presumption as to tax does not exist. Tax and fee. In a case of a fee, there is a specific service rendered to the fee payer. There is a quid pro quo. Whereas for the taxpayer, no direct services are rendered, but the services assumes the form of a public expenditure rendered to the public at large. Then we will see how is the tax system in India. Tax system in India. The tax system of British India reflected a characteristic of a traditional agricultural economy. Revenues of the central government were dominated by the custom duties as domestic requirement for the manufacturers. Goods were dominated by the custom duties as a domestic requirement for the manufactured goods, were met mostly from the imports, chiefly from the Britain and other Commonwealth countries, and import duties were levied on almost all items of imports, whereas major items subject to export duties were jute and tea, in which India enjoyed the nearly monopoly in the world market. Various customs and tariff enactment were passed from time to time. Now the GST also comes, so GST also one of the revenue for the central government, and proportionally it is divided to the state government later part, which is clearly given in the GST. And here our topic is only taxation, hence we will restrict ourselves with the tax. Let me see the taxation. What is meant by taxation? Article 265 of the Constitution mandates that no tax shall be levied or collected except by the authority of law. It provides that not only levy but also the collection of a tax must be under the authority of some law. That is what the tax law says, what the tax says, the taxation says. And we will see what is the tax laws. And when you come to the tax laws are highly complex, complicated, and beyond understanding of a taxpayer. The words and expressions used not simple. Many sections contain subsections, clauses, subclauses, provisos, etc. Many deeming provisions have been inserted. Meaning of an expression is extended by way of explanation, and it is curtailed by way of proviso. sometimes more than one provisos and explanations meaning differently. Let me see the another heading, subheading principle of strict construction. How the strict construction should be there. The manner in which the Income Tax Act has been drafted leaves a great scope for the litigation. For this purpose, principles of interpretation have to be applied. Of course, if any act would be there, generally there would be not 100% it will be made, there will be certain definitely loopholes. That is the reason every act will be amended later part. That's what we generally see in case of statutes or acts are concerned. These principles themselves are not infallible and would depend on the facts of each case. The two well settled principle of interpretation. I repeat, the two well settled principle of interpretation as applicable in taxing statutes. What are they? Let us see. Number one, there is no equity in tax, and the principle of strict or literal construction applies in interpreting the tax statutes. Hence, on the plain language of the statute, if the assessee is entitled to two benefits, he has to be granted both these benefits. Here, assessee means the person who is going to pay the tax is said to be an assessee, and the assessee is entitled to two benefits. He has to be granted both these benefits. And number two, if these are two reasonable interpretations of taxing statutes, the one that favors the assessee has to be accepted. Suppose if the two interpretation would be there in the statute, one disfavors, one favors, or one is punishable, or it is a burdensome on the assessee, and one is a lenient, then naturally, which is lenient or which is beneficial, the one favors the assessee has to be accepted when there are two reasonable interpretations are given in the statutes. Let us see that how a statute is an edict of the legislatures, and the conventional way of interpreting or construing a statute is to seek the intention of its maker. The maker here for the central statutes are the central parliament, and for the state statutes are the state legislatures, as we know in our earlier classes also. A statute is to be construed according to the intent of them and make it. I repeat, a statute is to construed according to the intent of them and that make it. Here them means parliamentarian or the state legislature who make such a statutes. And the duty of judicature is to act upon the true intention of the legislature. And it is the judicature means the judiciary which will give the interpretation of the to know the intention of the legislature. The men are sententiam. Let you put it again. The mens are sententia legis. If a statutory provision is open to more than one interpretation, the court has to choose that interpretation which represents the true intention of the legislature, which is also referred to as the legal meaning of the statutory provision. The intention of the legislature assimilates two aspects. Number one, in one aspect, it carries the concept of meaning, that is what the words mean. Number two, in other aspect, it conveys the concept of purpose and object, or the reason and spirit pervading through the statutes. And the purpose and object, reason and spirit. And these things we will see in the side heading in the later part of our class. And that is the two aspect of it where the one has to be understood. Now come to the strict construction and what exactly it says. In interpreting a taxing statutes, the court must interpret the statute as it stands, and in case of a doubt, the court must lean towards the taxpayer. I repeat, in interpreting a taxing statute, the court must interpret the statute as it stands, and what actually it says means literally interpretation should be done. And in case of a doubt, if any doubt would come, the court must lean towards the taxpayer, means toward the SSC. Rather, we can that what we studied earlier. The words of the fiscal statutes neither are to be neither elaborated nor restricted. That means the words of fiscal statutes means tax laws, tax statutes, or financial acts neither are to be elaborated nor it will be restricted. The exact meaning should be taken as it is. The basic rule with regard to the construction of a taxing statute is that they should be strictly construed. I repeat, the basic rule with regard to the construction of taxing statute is that they should be strictly construed. Note the point, strictly construed. The well-established rule in the familiar words of Lord Simon and reaffirmed by the Lord Halsbury, that means the subject is not to be taxed without a clear words for that purpose, and also that every act of parliament must be read according to the natural construction of the words. In taxing a act, one has to look merely at what is clearly said. There is no room for any intendment or presumption as to tax. I repeat, there is no room for any intendment or presumption as to tax is concerned. Nothing is to be read in, nothing is to be implied. I repeat, nothing is to be read in, nothing is to be implied. One can only look fairly at the language used. I repeat, one can only look fairly at the language used in the statute. The rationale for the strict construction of the taxing statutes lies in the fact that they impose pecuniary burdens. Therefore, in some senses, they operate as penalties. It is on the basis of this that clear and unambiguous language is required in order to make out a charge of a tax. A tax is imposed for a public purpose for raising the general revenue of the state. A taxing statute is to be strictly construed. Lord Halsbury and Lord Simon stated, which I already quoted earlier, but I repeat again. I repeat again here, or better to say I repeat, because repeat or again both stand the same meaning. So either I should have say repeat or I should say again. So I repeat, the subject is not to be taxed without clear words for that purpose, and also that every act of parliament must be read according to the natural construction of its words. That is the Simon as well as the Halsbury says regarding the interpretation of the statute, especially taxing statutes are concerned. It is settled law that a taxation statute in particular has to be strictly construed. Of course, every time we will read, and there is no equity in taxing the provisions. That is decided in the H.S. Lakshmi Bai versus CIT. That is the Commission of Income Tax. That is CIT means. The subject is not to be taxed without clear words for that purpose. So CIT versus Provident Investment Company Limited also the same case law, the same principle is used. And this principle is also used, that is the subject is not to be taxed without clear words for that purpose in Hansraj and Sons versus State of Jammu and Kashmir. Let me see in one of the case law, A.V. Fernandez versus State of Kerala. His Lordship Bhagwati Judge has stated the principle of taxing laws as follows. Is a Bhagwati's statement which is stated in this case law. In construing the fiscal statutes and in determining the liability of the subject to tax, one must have regard to the strict letter of the law. The same thing, that means construed strictly. If the revenue satisfies the court that the case falls strictly within the provisions of the law, the subject can be taxed. If, on the other hand, the case is not covered within the four corners of the provisions of the taxing statute, no tax can be imposed by inference or by analogy or by trying to probe into the intention of the legislature and by considering what was the substance of the matter. So, the no other idea should be given. The only idea which the intention of the parliamentary did it, that exactly that should be construed and that should be interpreted. That is said in Bhagwati in that case law. In another case law, in Associate Cement Company Limited versus Commercial Tax Officer, and here the E.S. Venkataramaya, judge of the Supreme Court, speaking for the majority, said, tax, interest and penalties are three different concepts. Tax becomes payable by an assessee by virtue of charging the provision in taxing statute. Penalty ordinarily becomes payable when it is found that an assessee has willfully violated any of the provisions of the taxing statute. Interest is ordinarily claimed from an assessee who has withheld payment of any tax payable by him, and it is always calculated at the prescribed rate on the basis of the actual amount of tax withheld and the extent of the delay in paying it. It may not be wrong to say that such interest is compensatory in character and not penal. And that is the statement made by the Venkatrama in the Associate Cement Company Limited versus Commercial Tax Officer. Then we will see what is the remedial statutes are known. Here, of course, we will see that remedial statutes and how the penal statutes will work over there. So, throw light on it. Remedial statutes are known as a welfare or beneficial or social justice oriented legislations. Penal statutes, on the other hand, those which provide for the penalties for contravention of the law and are directed against the offender in relation to the state by making him liable to imprisonment, fine, forfeiture, or other penalty. A remedial statute receives a liberal construction, whereas the penal statute is strictly construed. In case of a remedial statute, the doubt is resolved in favor of the class of persons for whose benefit the statute is enacted, whereas in the case of penal statutes, the doubt is resolved in favor of the alleged offender. That is the difference. We will see it. The principle applied in the constructing a penal act is that if in construing the relevant provision there appears any reasonable doubt or ambiguity, it will be resolved in favor of the person who would be liable to the penalty. I repeat, the principle applied in construing a penal act is that if in construing the relevant provisions there appears any reasonable doubt or ambiguity, it will be resolved in favor of the person who would be liable to the penalty. Here, who is going to be penalized, so some lenient view is given, and that is in favor of that person and who would be liable to the penalty. If there are two reasonable constructions, we must give the more lenient one. Again, as I had said earlier, if there are two reasonable constructions are there, so we must give the SSC or the person who is going to be penalty the lenient one. The court must always see that the persons to be penalized comes fairly and squarely within the plain words of the enactment. It is not enough that what he has done comes substantially within the mischief aimed by the statute. Then that was the thing. A penal provision has to be construed strictly, as we said earlier. Yes, naturally, in the last class we said a penal provision has to be construed strictly. In the last lecture we discussed. Let us throw light on those side headings, like I expressed earlier, that is prospective operation, meaning in the common parlance, machinery, new assumption as to tax, etc., etc. So let us see how these, including the exemption clause of strict construction, let us see how their impact on the strict construction of the tax statutes are concerned. First, we will see the charging section. The foundational principle for the charge under the tax statutes: no tax can be imposed on the subject without words in the act clearly showing an intention to lay a burden upon him. The section charges the tax must have clear words. Before taxing any individual, it must be clearly established that the person to be taxed falls within the purview of the charging section by a clear words. I repeat, before taxing any individual, it must be clearly established that the person to be taxed falls within the purview of the charging section by clear words. There is no implication of the law. If a person can't be brought within the four corners of the law, I repeat, if a person cannot be brought within the four corners of the law, he is free from tax liability. That is the charges section clearly says. And we will consider one of the case law. In Calcutta Jute Manufacturing Company versus Commercial Tax Officer, the Supreme Court held that in case of interpreting a taxing statute, one has to look into what is clearly stated. I repeat, the Supreme Court held in this case law, in the case of interpreting a taxing statute, one has to look into what is clearly stated. Stated where? Stated in the statute. There is no room for us searching the intention, presumption, or equity. So exactly what is stated, that should be taken into consideration and the case should be decided. In Mathuram Agrawal versus State of Madhya Pradesh, the Supreme Court held that words cannot be added or substituted to find a meaning in a statute so as to serve the intention of the legislature. Every taxing statute must contain three aspects: subject of tax, person to be taxed, and the rate of tax. I repeat, for every taxing statute must contain three aspects. Number one, subject of tax, and person to be taxed, and the rate of tax. Means Subject of tax means which subject the tax would be levied. Person to be taxed on whom the tax would be imposed, that is SSC, and the rate of tax and what is the percentage of the tax would be there, which is clearly given in the Tax Act. Clear intention to impose or increase the tax. It is another side heading. And what the clear intention to impose or income or increase the tax. The intention to impose or increase the tax or duty must be clear and in and unambiguous language. That would be the actually the intention should be there. It should be clear. In case of Steel Authority of India Limited versus Commission of Central Excise, the question was whether the raw naphtha intent for use in the manufacture of the fertilizers was exempted although it was not actually used. The question here comes is, the question was whether the new raw, R-A-W, raw naphtha, NAPHTHA, then the naphtha balls will say Dambar in Telugu. But let us see. Raw naphtha intended for use in the manufacture of the fertilizers was exempted, although it is not actually used. Even though it is not used, whether it comes under the exemption clause or not. As we said in the last but one side heading, the exemption clause, and there also this case law is useful. It was held that the exemption notification only required proof that the raw naphtha was intended for use in the manufacture of the fertilizers, and there was no further requirement that it was actually so used. Hence, it was purchased with the intention to be used for the manufacture of the fertilizers. It was exempt even though it could not be used for some reason subsequently. That means if it is purchased, even though it is not used over there, but still exemption clause one can claim because we have to construe the tax statute um, strictly. That is the reason. And we should whether you use it, may not use it, it will come under the exemption clause. The process of the construction combines both the literal and functional approaches. In the case of Gem Granite versus Commission of Income Tax, the Honorable Court observed that what one may believe or think to be the intention of the Parliament can't prevail if the language of the statute does not support that view. Thus, object of the statute has to be gathered from the language and not on one believes or think. I repeat, thus, object of the statute has to be gathered from the language which is used in the statute and not on what one believes or thinks and probabilities and combination, permutations and assumptions and beliefs. This should not be used over there, but strictly should be construed in the taxing statutes are concerned. Then another side heading is the prospective operation, that when the statute will be operative. When you see the cardinal principle of tax laws is that the law to be applied to assessee is the law in force in the assessment year unless otherwise provided expressly or by necessary implication. No retrospective effect to the fiscal statutes is possible unless the language of the statute is very clear and plain. In Reliance Jute Industry Limited versus Commercial Tax Officer, fiscal statutes are generally not retrospective, otherwise expressly provided by a necessary implication. Here, retrospective in the sense effective from the past. That is the retrospective. If it is retrospective, it should be clearly mentioned in the statute itself. That is what is decided in the Reliance Jute Industries Limited versus Commercial Tax Officer. Then we will see the meaning in common parlance, how the meaning should be taken in common parlance. In finding out the meaning of the taxing statutes, the meaning in common usage or parlance, special in commercial and trade circle must be considered. Yes, the special and a common parlance should be used, but there is no other beliefs and other assumptions should be taken into consideration. Comes the next heading is side heading is machinery provisions. Machinery provisions mean the procedure for calculation and collection of tax. The person who claims the exemption has to establish it. That is National Tax Traders versus Commission of Income Tax. The Supreme Court held the fiscal statute must be construed strictly. Yes, it should be calculated like a mathematics 2 into 2 4. That is a 4 only, but not 5 in that way. No presumption as to tax. As regard to the imposition of tax, no presumption exists. Yes, we already discussed. It can't be drawn by implications or analogical extension. The presumption for the equity and against the penalty of taxation exists. That is, in Muhammad Ali Khan versus Commission of Wealth Tax, it was held that no tax can be imposed by inference, analogy, or probing into the intention of the legislature. Fiscal statutes should be read as a whole. That means the entire statute should be read as a whole, not in a piecemeal basis. That means, let me see what is that. The entire provision of the fiscal statute has to be read as a whole and not in a piecemeal to find out the intent of the legislature. Yes, the statute should be read, then we know the intention of the legislature. Then the another side heading is the no spirit of law. A person is not liable to tax on the spirit of law and or logic or reason, but he should be taxed on the exact what's meaning only. Then comes the substance and of matter. The tax authority must consider the legal aspect of the particular transaction for a levy of tax. This is called substance of the matter, means on which matter the levy of the tax should be there, or means imposition of the tax should be there. Court fee act, if the court fee is high, then it affects the right of the aggrieved person to seek remedy. In interpreting the court fee act, the benefit of the doubt always goes to the assessee. Double taxation in interpreting the fiscal statute, if one meaning gives rise to the double taxation and other meaning gives rise to the single taxation, then the interpretation must be in favor of the single taxation only. Yes, this we already discussed. Delayed payment of tax. Interest is levied by tax authorities on delayed payment of tax. If provision exists, such delayed payment is valid. Yes, delayed payment is there. Yes, imposition of the penalty will be there. It's a valid. Penalty is there. No criminal act. The penalty provisions can't be equated with the criminal statute as a criminal act requires a mention. When you say the criminal acts are there, naturally you will see the guilty mind, whether the guilty mind is there or not. And we have seen that in one of the case law where a teacher has given a room for the rent for the student and students using the cannabis and where the landowner, the owner of the house also be liable, but court held that the owner doesn't have the guilty mind, hence she is not liable. That we saw in the earlier class, that is the strict construction of the penal statutes are concerned. In short, the general rule of construction is that in case of a doubt, it is decided in the favor of the taxpayer, even if such decision is detrimental to the government. I repeat, in general rule of construction in the tax statute is that in case of doubt, it is decided in favor of the taxpayer, means SSC, if such a decision is detrimental to the government also. Yes, exempt class, we will see how the strict construction will be there in exempt class. Exempt class also to be construed strictly. Yes, the law is well settled that a person who claims exemption or concession has to establish that he is entitled to that exemption or concession. Yes, a person who is going to be exempted or getting the concession, the burden lies on him to prove or get that he will fulfill all the conditions of the exemption or concession uh, elements. Let me go further. A provisions providing for an exemption or concession for or exception, as the case may be, has to be construed strictly with certain exceptions depending upon the setting on which the provision has been placed in the statute and the object and purpose of the to be achieved. If exemption is available on the complying with certain conditions, the conditions have to be complied with. The mandatory requirement of those conditions must be obeyed or fulfilled exactly. Though at times some latitude can be shown, if there is a failure to comply with some requirements which are directory in nature, the non-compliance of which would not affect the essence or substance of the notification granting exemption. Let's see, the last point is conclusion. In conclusion, we will say like this. Going by some of the principles, cardinal points, authorities, and some of the side headings and the case laws regarding the strict construction, the strict constructionist means the person who makes such a construction is called the strict constructionist approach appear to be the only guide to construing a tax statute in strict sense and not based on the whims and fancies by enlarging the scope and intention of the parliamentarian who enacted such a tax statutes. The strict rule of construction was inspired by a need to balance the power of the individual against the state and prevent the state from penalizing the individual unnecessarily. It is important for lawyers or judiciary and academicians to be mindful of the above developments in the principle of construction and interpretation of legislation, because words used to draft legislation are imperfect. So judiciary interferes and interpret the tax statutes are very strictly. And that is the end of today's online class. Thank you very much listening. Goodbye.